Hello everyone, in this video we will be covering MCQs of Registration Act, which is the Act of 1908, and I have made MCQs from all the provisions of this Act, but I have comprised only important MCQs. So in making the video I have not gone into any of the state amendments, it is without any of the state amendments. So let's begin it. Question number 1 provides enforcement date of Registration Act. The enforcement date is 1st of Jan 1909. It's not 1908. So A is the correct answer. Second question is absence or vacancy of registrar of the district shall be filled up by. So the correct answer would be C, but the provision says that until state government fills up the vacancy. So until if is the main authority obviously is the state government, but until state government fills up the vacancy shall be filled up by Inspector General. Next question is on the absence of the sub registrar, appointment of sub registrar shall be made by. So correct answer is registrar. Registrar is the authority to appoint sub registrar when the sub registrar is absent. So A is the correct answer. Next question is who shall provide for the office of every registering officers the books necessary for the purposes of this act. So as per the provision, state government provides those books. So A is the correct answer. Next question is forms in the books provided be prescribed by. So जो forms होंगे books में उसको कौन prescribe करेगा? So as per the provision, Inspector General is the authority. So B is the correct answer. Next question is who shall supply the office of every registrar a fireproof box. So it is provided there that सारे registrar offices में एक fireproof box होगा and it shall be supplied by state government. So A is the correct answer. Documents of which registration is compulsory, it is provided in which section? So section 17 is the section जिसमें mandatorily जो documents registrable हैं उसके बारे में बताया गया है. So section 17 is the answer. Next question is object of registration under section 17 is. So it is a very important question. So options are registration of document reflecting transaction of property. So option A says the object is to register the document reflecting transaction of property. B says to register the property in transaction. And C says both registering the document as well as the property, and D none of these. So as per the provision and the Registration Act, its object is to register the document, not the property. So A is the correct answer, which says that registration of document reflecting transaction of property. So we do not register the property, we register the document in which the transaction is with regard to that particular property, a particular property situated in the jurisdiction area where the office of registrar is located. So it is the document which we are registering, the authority registers, it's not the property. So A is the correct answer. Next question is which amongst these is compulsorily to be registered? So इसमें से क्या compulsorily registerable है and section 17 में provided है compulsorily जो भी documents register होने चाहिए. So what is the compulsorily registerable out of these? A says any decree or order of a court made on compromise and comprising immovable property which is the subject matter of suit or proceedings. B says any certificate of sale granted to the purchaser of any property sold by public auction by a civil or revenue officer. C says composition deed, and D none of these. So it is just the question directly asked from the provision. If you read the provision properly, you can find it out that none of these are compulsorily registrable. There may be confusion about the option A. B and C are expressly given in section 17 subsection 2, but A is also there, but there may be some confusion about it. So A says any decree or order of court made on compromise and comprising immovable property which is the subject matter of the suit. So the property which is not the subject matter of the suit, when there is a compromise decree, that document becomes compulsorily registrable. But if it is the compromise is there and the property, immovable property is the subject matter of the suit, in that case it is not compulsorily registrable property. So you read properly that if it is subject matter of the suit in compromise decree, then it is not compulsorily registrable. But if it is not the not the property which is subject matter of the suit, immovable property, then it is not it is compulsorily registrable property. So none of these is the answer. इनमें से कोई भी प्रॉपर्टी कंपल्सरीली रजिस्ट्रेबल नहीं है. नेक्स्ट क्वेश्चन, documents to be registered must be presented to the proper officer within. Options are 4 months from the date of execution, 4 months from the date of from the making of the document, 2 months from execution, 2 months from making. So the provision provides 4 months from the date of execution, not making. So correct answer is A, 4 months from the date of its execution. Next question is, a will for its registration must be produced within. So will को registration के लिए कब किस time तक produce किया जा सकता है? So it is, their options are 4 months from its execution, 3 months from execution, 6 months from execution. So if you read the act properly, there is no limitation for production of the will for registration. So it can be produced at any time after its execution. So D would be the correct answer. Next question is, re-registration of document is provided under section. So it is provided under section 23 capital A. D is the correct answer. Next question is, documents executed by several persons at different times may be produced for registration within 3 months, 3 months from execution, 4 months from execution, or 6 months from each execution. So first option is 3 months from last execution, 3 months from each execution, 4 months from each execution. So if you have read the provision, the answer, the option C would be the correct option. 4 months from each execution is the answer. बहुत सारे लोग डिफरेंट टाइम्स पे रजिस्ट्रेशन कर रहे हैं अलग अलग डॉक्यूमेंट्स का, तो सारों का अपना अपना टाइम पीरियड होगा. ईच एग्जीक्यूशन से 4 मंथ्स तक उसको रजिस्टर किया जा सकता है. सो सी इज़ द करेक्ट आंसर. नेक्स्ट क्वेश्चन, डिले इन प्रेजेंटेशन ऑफ डॉक्यूमेंट मे बी एक्सक्यूज्ड ओनली व्हेन. सो किन सर्कमस्टांसेस में डिले को एक्सक्यूज़ किया जा सकता है प्रेजेंटेशन के लिए डॉक्यूमेंट की? सो इट इज़, ऑप्शन इज देयर वाज अर्जेंट नेसेसिटी और अनअवॉइडेबल एक्सीडेंट. सो इफ़ यू रीड द प्रोविजन, बोथ can be the ground for which it may be excused. So C is the correct answer. Next question is, delay in presentation of document may be excused up to. So delay कितने टाइम तक एक्सक्यूज़ हो सकती है? वो कितना, जैसे 4 मंथ्स का टाइम पीरियड इस प्रेजेंटेशन के लिए, तो अगर 4 मंथ से आगे डिले कितना टाइम तक एक्सक्यूज़ किया जा सकता है? सो इट प्रोवाइड्स, द सेक्शन प्रोवाइड्स 4 मंथ्स ऑफ डिले कैन बी एक्सक्यूज्ड. तो 4 मंथ के आगे डिले नहीं होना चाहिए. So A would be the correct answer. Next question is, fine to condone the delay in presentation of document may be. So as per the provision, it is 10 times the registration fee. So जो भी delay को condone करने के लिए fine भी impose किया जा सकता है, तो it can be 10 times the registration fee. इससे ज़्यादा नहीं हो सकता, 10 times से ज़्यादा नहीं होगा. So 10 times of the registration fee. B is the correct answer. Next question is, maximum time for registration of documents executed out of India. So whether it is 6 months, 4 months, 2 months. So correct answer is 4 months from arrival in India. So B is the correct answer. Next question is, which amongst these is correct? A says, if the principal at the time of executing resides in any part of India in which this act is in force, a power of attorney shall be executed before and authenticated by magistrate. B says, a will can be presented only after death of the testator. C says, will shall be deposited under an open cover letter. And D says none of these. So if you see, all of the options are incorrect, because if the principal at the time, A says, if the principal at the time of executing resides in any part of India in which this act is in force, a power of attorney shall be executed before and authenticated by magistrate. It is not the correct option, क्योंकि जिन एरियाज़ में एक्ट फोर्स में नहीं है, उन्हीं एरियाज़ में मजिस्ट्रेट ऑथेंटिकेट करेगा पावर ऑफ अटॉर्नी को. जहाँ पर एक्ट एनफोर्स्ड है, वहाँ पर रजिस्ट्रार और सब रजिस्ट्रार इज़ दी अथॉरिटी. सब रजिस्ट्रार एंड रजिस्ट्रार इज़ दी अथॉरिटी. सो जहाँ पर एक्ट फोर्स में नहीं है, वहाँ पर रजिस्ट्रार एंड सब रजिस्ट्रार इज़ दी अथॉरिटी. सो दिस इज़ करेक्ट, इनकरेक्ट ऑप्शन. बी सेज, अ विल कैन बी प्रेजेंटेड ओनली आफ्टर द डेथ ऑफ टेस्टेटर, विच इज़ ऑल्सो इनकरेक्ट. डेथ कि पहले will को present किया जाना चाहिए. C says a will shall be deposited under an open cover. That is also wrong. Will is to be deposited under a cover. It cannot be an open cover. So this is also wrong. So none of these is the correct answer. सारे ही options incorrect हैं. So D is the correct answer. 19. The next question. Persons exempt from appearance at registration office. So what people are exempted from personal appearance? A option is a person in jail under civil or criminal process. B says a person convicted of an offence. C says a person accused of committing moral turpitude. And D all of these. So confuse नहीं होना है. ऐसे questions में options similar लग सकते हैं, but convicted person and a person committing moral turpitude. अगर कोई convicted है और moral turpitude commit किया है तो what is the problem there in their personal appearance? It's very logical. अगर वो जेल में नहीं है तो obviously they can appear. So A is the correct answer and also provided expressly in the provision. A person in jail under civil or criminal process, this person can be exempted from its personal appearance. So A would be the correct answer, not all of these. Next question is deposit of will provided under. So deposit of will is provided under section 42. C is the correct answer. Next question is details of the deposit of will shall be made in. So the book number is book number 5. It is provided under section 43. So correct answer is D. Next question is which amongst these is correct with regard to proceedings after death of the depositor of will. So इनमें से क्या correct है with regard to proceedings after death of the depositor of will. So A says the will under the sealed cover will have no effect after the death of the depositor. So as per the provision it is not correct statement. B after the as per the provision a will under the sealed cover will have no effect. Will in fact will have effect only after the death of the depositor, because under जो sealed cover will होगी वो death पे ही open होगी और accordingly उसका जो भी उसमें contents होंगे उसको effect में लाया जा सकता है. So A would be incorrect. B original will shall be given to the applicant only after the death of the depositor after opening the cover in presence of the applicant. So if you read the provision properly, only copy of the will can be given, not original. So it is also incorrect. C says the registrar can open the cover of the deposited will only on the application and before the death of the depositor. So this statement is also incorrect because death की पहले application लगा के कोई registrar open नहीं कर सकता, because as per the provision only after death ये application करने के बाद जो apply कर रहा है वो उसकी presence में registrar open करेगा जब depositor की death हो गई है उसके बाद. So none of these is correct. D is the correct answer. Next question is time from which registered document operates. A says from the date of registration. B says time from which it would have commenced to operate if no registration thereof had been required or made. C says after the order of registration has been passed by the registrar of its registration 1 month after the registration of document. But the correct answer is B, time from which it would have commenced to operate if registration thereof had been required or made. No registration had been required or made. So B is the correct answer. Next question is which amongst these is correct with respect to unregistered documents required to be registered. So unregistered document जो register होने चाहिए थे उनके बारे में which statement is correct? A is may be received as evidence of a contract in suit of specific performance. B says may be received as evidence of part performance under 53 capital A of TPA. C says may be received as evidence of any collateral transaction not required to be effected by registered instruments. So as per the provision all of these are correct. The unregistered document can be used for any of these purposes. Next question is what would be the effect of non-registration of documents required to be registered. So A says shall not affect any moral property, shall not confer any power to adopt. C says shall not received as evidence of any transaction affecting property. So as per the provision all of these are correct. The effect would be that the moral property comprised in will not be affected, neither the power of adopt is affected, as well as it cannot be received as evidence of any transaction which affects such property. So all of these is the correct answer. D is the correct answer. Next question is, which section provides that the registered document relating to lend to take effect against unregistered documents? So the provision is section 50. It is provided under section 50. Next question is, book 2 of registration contains. So book 2 में क्या provided है? For what purpose book 2 would be? So A is the correct answer. It shall contain record of reasons for refusal to register. So A is the correct answer. Next question is, book 4 of registration contains. So option A is document registered under D and F of section 18 which do not relate to immovable property. B says document registering under clause D and F of 18 which relates to immovable property, and C says register of non-testamentary document relating to immovable property. So provision answer would be option A. जो बुक 4 है उसमें इसी तरह के डॉक्यूमेंट्स को रिकॉर्ड किया जा सकता है विच आर रजिस्टर्ड अंडर 18D and F, and if they do not relate to immovable property, only then they would be recorded under book 4 of the registration. So A is the correct answer. Next question is, how many indexes shall be made in registration offices? So D is the correct answer. 4 index shall be made. Next question is, what book shall at all times be open to inspection by any person applying to inspect and for copies on payment of fee? So as per the provision, it is book 1 and 2. Book 1 and 2 can be received by any person and inspected by any person. Its copy can be received by any person on application. So it will be open for general public, general people. They can apply and have inspected and have a copy of it. So 1 and 2 is the correct answer, option A. Next question is, what particulars must be endorsed on document admitted to registration? So options are first, a signature and addition of every person admitting the execution of the document. Second, any payment of money or delivery of goods made in presence of the registering officer in reference to the execution of document. C, the signature and addition of every person examined in reference to such document. So as per the provision, all of these are correct. All of these must be endorsed on the document which are admitted for registration. So all of these is the correct answer. D is the correct option. So the next question is, who shall exercise a general superintendence over all registration offices in the territories under the state? So as per the provision, the correct answer is Inspector General. B. It's not state government, it's Inspector General who shall exercise general superintendence over all the registration offices. So B is the correct option. Next question is, who may remit wholly or in part the difference between any fine levied under section 25 or section 34 and the amount of the proper registration fee? So remit कौन करेगा? So who is the authority? Again it is Inspector General who can remit such amount. So B is the correct option. Next question is, reasons for refusal to register document shall be recorded in which book? So B is the correct option. Book number 2 shall contain the reasons for refusal to register the document. B is the correct option. Question 35 provides, an appeal shall lie against an order of sub-registrar refusing to admit a document to registration before. So appeal, sub-registrar की appeal किस authority के पास होगी? So the correct answer is A. Registrar would be the authority, appellate authorities against the order of sub-registrar when it refuses to admit a document for registration. Next question is, limitation period to file an appeal against the order of sub-registrar. So 30 days is the time period which is provided under the provision. Next question is, remedy against sub-registrar's refusal to register a document on the ground of denial of execution. So denial of execution के against sub-registrar का जो refusal है उसके against क्या remedy होगी? So the options are an appeal before registrar within 30 days from the date of order, an application to registrar within 30 days, and an appeal to Inspector General within 30 days, and D says such order is final, thus no remedy is available. So the correct option is, an application to registrar within 30 days from the date of order shall be filed against such order of sub-registrar in which he refuses to register the document on the ground of denial of execution. So denial of execution is a different thing. So here the remedy would be an application within 30 days. Next question is, remedy against registrar's refusal to register a document is. So options are, institute a civil suit within 30 days, file an application to Inspector General within 30 days, to file appeal to district judge within 30 days, and appeal to High Court within 30 days. So जब registrar refuse कर रहा है, not the sub registrar. If registrar refuses to register, then only option would be to file a civil suit within 30 days. So A is the correct option. Next question is, a civil suit against the order of refusal to register document by registrar shall be instituted in. So it is asking the jurisdiction. A says the civil court within whose original jurisdiction the plaintiff resides. B says the civil court within whose original jurisdiction the office in which the document is sought to be registered is situated. C says the civil court within whose original jurisdiction the property being the subject matter of the document is situated. D said the suit can be instituted in any of these places. So there can be a confusion that most of the times we think that the jurisdiction would be where the property is situated, but C is the wrong would be the wrong answer. B is the correct answer. It provides within whose original jurisdiction the office in which the document is sought to be registered is situated. So जहाँ पर registration के लिए document present किया गया है वो office जिस jurisdiction में situated है उस civil court में होगा. So B is the correct answer. Next question is, fees for registration shall be fixed by. So state government is the authority. D is the correct answer. Next question is, fees for registration of documents under this act shall be payable. So the options are when the document presented gets registered, on presentation of document, on date of application for the registration of document, within 30 days from presentation of document for registration. So as per the provision, the correct answer is B. On presentation of document, fee pay karni hogi. So B is the correct answer. Next question is, immovable property under Registration Act as defined under the Act includes. So option A, hereditary allowances, growing crops, grass, none of these. So out of these options, option A is correct. Hereditary allowances are immovable property, are considered as immovable property under the Act. So A is the correct answer. Next question is, lease includes. So A says agreement to lease, B says counterpart, C says kabiliyat, and D all of these. So all of these is correct answer. Lease के definition में all are included. So D is the. Next question is, movable property includes. A says fruit and juices in trees, B says fisheries, C hereditary allowances, and D all of these. So the correct answer is A, fruit and juices in the trees. So fisheries is considered as immovable property, hereditary allowances are also immovable property as per the Act. So A is the correct option. It is considered as movable property. Minor means, as per the Act, what as defined in the Act minor means. So A says person who has not attained 18 years of age, B says person has not attained 21 years of age, and C says person who according to the personal law to which he is subject has not attained majority, none of these. So confusion would be in option A and option C, but as per the definition there, C would be the correct answer. It is defined like this only, that person who according to the personal law to which he is subject has not attained majority shall be minor. So C is the correct answer. Last question is, district court includes. A says High Court in its ordinary jurisdiction, original civil jurisdiction, and B says only civil court of a district in its ordinary original jurisdiction. C says Supreme Court in its ordinary original civil jurisdiction, and D says A and B both. But the correct answer is district court की definition में High Court in its original civil jurisdiction include किया गया है under the Act under this definition. So A is the correct answer. So thank you so much for watching this video. If you like the video, please subscribe the channel and see my other videos as well. Thank you so much for watching.